Hello, everybody, and welcome to Hearsay. My name is Michaela Butt, and I'm a project lead here at Hearsay, and I have the honor to introduce to you the second half of the Professor Zaidi immigration law conversation. With that said, I do want to let you folks know that this interview was recorded a few months ago, and there is a brief discussion regarding speculation and ways in which the Carney government may be going regarding immigration law. If this is a piece of information you are interested in learning more about, make sure you consult the most up-to-date references and resources. With that said, please remember that Hearsay is not legal advice. It is exclusively intended to be legal information. Without further ado, on to the rest of the interview.
What skills do you think are the most important that lawyers should work on to be the most valuable for their clients in immigration law?
There are so many different skills. One is communication. Part of being an effective lawyer is having very quick, prompt communication, particularly for emergencies or urgent matters. It is possible that a client is simply contacting you by email, by phone, by text message, whatever. But it's important to get back to them as soon as you can. Communication is one of the reasons why lawyers are complained about at the Law Society. When they receive complaints and they're investigated, often it's a lack of communication, which is interesting because we're supposed to be the most communicative profession in the world. But sometimes people just need advice, they need direction, and they might be stuck at the border, for example. And there's a crucial issue going on that needs to be addressed firmly. Another issue is organization in terms of file management. It's very important to keep up to date with your files as to who is being affected by various processes, particularly deadlines. This is true of any lawyer with a client in general. We often have to remember limitation periods for particular matters. But the same thing applies with immigration applications as well and immigration matters. So staying on top of deadlines, active file management is crucial. And in updating and informing the client of their present situation is also important. If you receive a letter from the government about your client, it's very important to communicate with the client about that communication. That letter or that update is, interestingly enough, it's sometimes the case that the client receives updates directly from the government when there's a representative on the file. And it's very important to tell the client that all communication should go through the representative prior to them receiving it. And it does happen sometimes, but it is possible the government doesn't know you're represented, and you never inform them of that. Simply hiring a lawyer doesn't mean that everyone knows you have a representative. And so communication, updating, active file management is very important. Not to mention keeping update with the trends in law. There may be a new major announcement related to a particular class of immigration, and that particular client of yours might be affected by that. So you have to stay on top of the news. You have to make sure that you communicate that new information to the client, if it affects them, of course. There may be major announcements or amendments to the statute, changes made by the Parliament of Canada, but it may not directly influence your client just yet. Maybe in the future it will. So there's a lot of advice to be given to clients as to changes going on in the profession, but ordinarily you want to just keep on top of information and regularly update your file so that you don't fall behind. That's a major problem with any form of representation.
Have there been any large or significant cases in relation to immigration law in recent years, particularly in relation to the Canadian Charter?
There are always a handful of charter rights cases or constitutional cases, human rights cases, dealing with Alberta Human Rights Act, for example. You may have cases that end up in Supreme Court of Canada, or in most cases you find in Federal Court of Canada. The thing about cases is that they all create different precedents. Vavilov is one of the main cases that has come to light recently after the Dunsmuir case, which was an earlier case dealing with procedural fairness and standards of review, where you're dealing with a reassessment of the law on how courts should either defer to an agency or whether they should construct their own opinion and basically overrule agency decisions. And there's a lot of clarification in today's world, especially after Vavilov, in terms of how to go about doing that. So what you see is kind of a realignment of different prerequisites as to what constitutes judicial review, what constitutes a proper review of courts on agency actions. But we also hear and see the, starting from the cases of like Baker, for example, on procedural fairness, we see a lot of abuse of discretion by agencies where they overstep the boundaries of their power, where they actually don't fulfill their statutory mandate, and they consider factors that are irrelevant to kind of overturn their own decisions. Courts don't like to see that, given the fact that agencies have broad powers of discretion. And that's what we call discretion. We study that in administrative law. Discretion means the power delegated to an agency and whether or not they properly exercise that power within the rule of law. These cases, Baker and Dunsmuir, Vavilov, and there's a handful of other cases. Ron Corelli is the case I always start off with in my administrative law class on the abuse of power and how an executive branch member, like say the premier, is not allowed to flaunt the law without having any vested powers to make key decisions. Sometimes they make corrupt decisions and decisions that are outside the boundaries of law. So these kinds of cases over the years have shaped Canadian administrative and constitutional law in terms of checking the branches of government, executive, legislative, and judiciary. But in the middle, you have the agencies with this great power and also the people that deal mostly with individual applicants. The branches are there for a reason. A separation of powers and the checks and balances in that system is different from the monarch system, where you have a king at the top or queen, and the monarchy is essentially replaced by the three branches, so it can dilute power and avoid a dictatorship. But even with that more democratic model, you have in the middle of all that the agencies who could be making bad choices, bad decisions. And so within the three branches, there is a possibility that someone makes the wrong decision, but there's some oversight by the other two branches. So that model is continually being aligned and realigned by these particular cases. And it's amazing how you can draw that diagram, the very simple diagram of having the executive, legislative, and judiciary branches constantly watching each other in the form of a checks and balances system. But at the same time recognizing that each branch carries great powers and they can do what the law intended for them to do. The question is, did they cross that boundary? And that's something that we call ultra vires in administrative law. That's when you go beyond your statutory powers. There are a lot of bodies or administrative bodies, institutions like courts, they have powers, but there are limits to power. And that's constantly being reminded of in these particular cases, whether it's Baker, whether it's Dunsmuir, which involved government employees, or Vavilov, which had to do with someone's parents being spies. Baker was a case where you had a Jamaican citizen who was living and working in Canada, but the immigration officer made decisions which were very irrelevant to the main point of the application for permanent residence. And that's one of the things that you'll see in these cases, and there are many cases throughout administrative and immigration that you'll see changing precedents with respect to the rule of law and just how agencies are allowed to carry their powers but with limitations. And sometimes they're overturned by courts. Most of the time, courts defer to agencies because they deal with the everyday wheelings and dealings of Canadians and non-Canadians. They are essentially the bureaucracy. But bureaucracy can hold up things too. And that's one of the things about, efficiency in our legal system. How do we create efficiencies? Is there a smarter, more effective, meaningful way of processing an application? This has been going on in the discussion of the legal system in Canada, how we can create systems of governance so that we don't create a backlog in our courts, how we can resolve or potentially resolve matters out of court quickly, efficiently, but fairly. Can that be done? And these cases that they're the more popular cases, but in all the cases that I have seen in immigration and administrative law and constitutional law, you will always see a constant realignment of major objectives of government and what they should be doing, government agencies, that is. And so it depends on which case you're studying, but there's often a move to innovate the program in some way.
Talking about innovations, has there been any new statutory developments in immigration law with this most recent government, or has it been kind of stagnant in terms of innovation?
That's an excellent question. The present Carney government is on track to change the immigration system in terms of introducing reforms. There have always been statutory developments every year, regardless of who's in power. There's a constant amendment to the different statutes that affect immigration, especially IRPA, Immigration Refugee Protection Act. But there's a whole series of other statutes that and regulations that are changing the scenery in Canada in terms of the machinery of government operating. One of them is the increased cooperation between federal and provincial governments. There is an active dialogue between the two governments, the two levels of government, on issues of provincial nominees. That's a system of permanent residence where the province or territory nominates the migrant, and afterwards the federal government will process their immigration application to stay in Canada. But that requires a great deal of dialogue and meetings, and that's what's been going on more actively in Canada with respect to the changes just to get things done. That helps the provinces meet their labor demands and needs. But it also reflects the fact that the Parliament of Canada has to introduce more laws that deal with unaccounted for issues like climate migration. Actually, climate migration is one of the papers I recently submitted for publication. I hope it gets published, but it's something that is not addressed in Canada. Climate migration is something that many people doubt and have doubted over the years, but it is a real thing, and it's affecting many of the Pacific Island nations, Australia, New Zealand, these other common law jurisdictions, even the United States, and you have countries that are receiving migrants as a result of environmental reasons, like drought, desertification, lack of water resources, and whatnot. There are many avenues of improvement that Canada can pursue with respect to Carney's announcement of reforming the immigration system. It's probably in the works right now of what his government is planning to do. I think IRPA will remain the main federal statute, but I think you will see, in my estimation, new legislation on point with different types of immigration. And it will be interesting to see how that's done in the midst of more interprovincial trade agreements being signed. That is actually going to speed up immigration because you can have greater mobility between the provinces. It's not just of goods and services, but it's people too. It's very similar to the European Union. That's what the EU is doing, and that includes mobility rights. So when people talk about tariffs, when they talk about, the response to the tariffs from the South and dealing with interprovincial matters, that's a great thing to see more commerce stimulated between the provinces. That should have been done a long time ago. But it's also going to affect mobility rights. It's going to affect immigration to a large extent because of the movement of labor and personnel, not to mention corporations or companies. So it's going to be interesting to see how that plays out because immigration is not in isolation. It is impacted by trade agreements. It's impacted by even tariffs. Maybe that's the topic of my next paper, but the interrelationship between tariffs and immigration. But the idea is that it's a good study to see how the economics is changing in Canada. I foresee the Carney government can introduce new legislation, new regulations that are constantly amended, but you might see new programs come into play, which is going to be very different from the Trudeau government, I think. It's going to be different because of the responses to recent announcements from the United States. So it's going to be a very interesting time to see the changes in immigration in Canada.
Has the Carney government signaled what type of changes specifically they'll be making to statutes on immigration?
Not yet. I have been tracking the Senate of Canada, the parliamentary committees on immigration in Parliament, in the House of Commons, and there is on the periphery, there is discussion about some of the new programs that need to be introduced into Canada, especially with international students. That, in my opinion, that issue was poorly managed, and because it has a great impact on Canadian institutions of learning, universities, colleges, not to mention employers, were all impacted by the cutting down of the quota of international students. And it was poorly conceived because it wasn't well thought out as to how much of an impact international students have on the Canadian economy. Whether it's renting a home, whether it's paying tuition, books, all of these are impacting our economy when you curb or limit the number of international students. I don't think that you'll see major announcements just yet with the Carney government. I think you have to give it a few months, if not another 6 months, before real action is seen. But the way I see Carney is that he moves quickly. He has a banking background, and he likes to see results. So you might see something before the end of December in terms of major announcements to immigration. But immigration news always changes, and there are constant reforms being made within the provinces. That depends on the province. But a lot is being done right now because Canadian employers need that change. They need to see more people, more qualified people, and they need to replace their workforce. And there is so much demand in every industry because of the demographic shift going on. The baby boomers have retired, or they have left their position, or they just died. And the population of Canada is not replacing itself to fill the niche of so many different industries and jobs. And that's happening throughout the world. It's not just Canada. This huge vacuum effect has created a huge demand for immigration because of that. That's the reason why countries have immigration. It's mainly to replace its population, and not just to reunite families, and not just to act as a tourism magnet, which is always helpful to the economy, but it's much deeper than that. We need to replace enough people in this society before we lose people. And that, of course, is something that every country keeps an eye on. Canada has a unique situation because our population is not that high. Being slightly over 40 million, plus or minus a few thousand people, you have an opportunity to advance in a very constructive way. Other countries like the United States, 350 plus million people is a lot of people. They have a big population to contend with, and they have much more to deal with in terms of illegal immigration than Canada does. So we have a pretty unique opportunity to advance here constructively, but that's why it's important to study comparative law. Look at Australia, which is very similar to Canada in terms of its population, and it's a common law country. It has a very similar immigration system as we do, but they have taken a more active a role in that regard. So Canada and Australia have a good relationship, and they can learn from each other in terms of what each country does in terms of reforming its immigration. Australia has done that over the last decade or so, which was a complete opposite of their very xenophobic policies from the past, 50s, 60s, 70s, even the 80s. Australia had very strict immigration criteria. Now they're wide open. So it's an interesting policy approach to Australia because they're in a different part of the world. But at the same time, they have reimagined their system. And I think Canada is coming close to reimagining itself too.
So for students, law students interested in immigration law, what areas of the field are emerging or underexplored that you think are opportunities for research or advocacy?
Excellent question. When you think of corporations, companies, investments, foreign investment in Canada, the movement of workers, the recruitment, hiring of individuals, skilled individuals, that plays a big role. Any law firm that deals with immigration matters tends to deal with, formerly NAFTA issues, now USMCA or CUSMA as we call it. Trade agreements are huge. They invite a discussion on mobility rights, on transferring jobs from one locale to another. When you're dealing with, just ordinary travel, exemptions of visa or visa requirements, you might have a diplomatic situation where the Canadian government is dealing with a very sensitive political matter, dealing with Canadians, like the two Canadians held in China, whom were released afterwards, and that required a great deal of diplomacy to be engaged with, and that's a part of immigration law too, except it intersects with international diplomacy. Embassies, high commissions, Canadian embassies and high commissions is something that I explore in my immigration class, as to what services they provide, like consular services. What happens when a Canadian is in jail in a foreign country? What procedures are triggered in those embassies or consulates, high commissions? They play a very active role. And not to mention that it's a source of employment for Canadian lawyers too. They can easily become a diplomat, a trade negotiator, if you can handle it. Then these are great places to go to. The United Nations, of course, many lawyers go to the United Nations, but just in terms of the Canadian government, you can be employed there too. Department of Justice, and then of course the individual embassies and consulates, high commissions throughout the world. Those are jobs too. They require finesse. They require a knowledge of the law, and especially international law, but also to protect Canadians. And so a lawyer might be working in an embassy dealing with some very urgent application or some situation involving a Canadian in that foreign country. There's all kinds of issues that emerge. Then, of course, there's family class applications, a generic application to bring someone's family from, say, Mexico to Canada. And there could be a marriage between a Canadian and a non-Canadian. And you have another example of a family class application for spousal sponsorship. There are those personal issues as well. And with respect to tourism, that is absolutely huge. There are many different people who are invited through invitation letters to attend Canada, but not only as a tourist, but as a business visitor. There's a special class for tourist business visitors who can stimulate business in Canada, whether it's attending a conference, whether it is setting up a trade show, being at a job fair, for example. All of these things can be set up by inviting that person over to Canada. Sometimes inviting someone who has a very popular name over to Canada to visit, it plays a big role in terms of, advocating for that event, as opposed to just being virtual. So there are so many applications of immigration and so many types of cases that you can face with immigration. I'll leave one more example. Canadians going to other countries like the United States and, completing, say, an E2 visa where they set up a business in the United States, and then they have to deal with tax issues and the IRS and CRA and whatnot, and then exploring tax agreements, reciprocity agreements between Canada and the U.S. These are the kinds of things you have to explore and research on the job as a lawyer. But it's very fascinating, and it improves vastly your knowledge of world affairs, but also tax law as well.
Great. Well, thank you so much, Professor Zaidi, for joining us today and offering us your knowledge on Canadian immigration law. That concludes our interview with Professor Kaamil Zaidi. You are listening to the Hearsay podcast. We're proud to present you with legal information, but please remember that this is legal information, not legal advice. If you require legal advice, please consult a lawyer.